Hi, my name is Nathan Jones and I'm a Special Counsel in McCabe Curwood's Litigation and Dispute Resolution Group. Today I'll be talking about two of the most interesting judgments delivered by the High Court of Australia in 2019. On 14 August 2019, the High Court delivered judgment in the case of Glencore International and Commissioner of Taxation of the Commonwealth of Australia. The facts were as follows. A law firm in Bermuda, Appleby, provided Glencore with legal advice with respect to the corporate restructure of Australian entities within the Glencore Group. Privileged documents relating to such advice were amongst documents which were stolen from Appleby's electronic file management system and provided to journalists. Glencore asked the Australian Taxation Office, or ATO, to provide an undertaking that it would not refer to or rely upon these privileged documents in exercising its statutory powers. The ATO did not accede to that request. Glencore commenced proceedings in the original jurisdiction of the High Court, seeking an injunction restraining the Commissioner of Taxation from making any use of the documents. Glencore claimed that legal professional privilege was itself a sufficient basis for the injunction sought. It stressed the importance of protecting privileged communications obtained by impropriety. Further, it contended that if an injunction will only be granted on the basis that documents are confidential rather than privileged, there is a gap in the law. The High Court unanimously dismissed Glencore's claim, holding that legal professional privilege is not a legal right which may found a cause of action. The court concluded that if there is a gap in the law, legal professional privilege is not the area which might be developed in order to provide the remedy sought. This decision is significant because it reinforces that the common law develops incrementally from settled principles. Here, the principle that legal professional privilege operates as an immunity from the compulsory production of documents was far too entrenched for the High Court to countenance Glencore's claim, which sought to create a new actionable right. The second High Court judgment that I am going to briefly discuss is Australian Securities and Investments Commission and Cobalt. The facts were as follows. Mr. Cobalt ran a general store in the far north of South Australia. He had a total customer base of 600 Aboriginal persons, more than half of whom could not add up. Mr. Cobalt adopted a system for the provision of credit which applied only to his Aboriginal customers. The system required, amongst other things, the customers to provide Mr. Cobalt with their debit card, linked to the bank account into which their wages or Centrelink payments were made, as well as their PIN. Every time the Aboriginal customers received income, Mr. Cobalt would withdraw all or nearly all of their money. The withdrawal of funds was subject to an informal understanding that half of the regular income was taken as repayment of debt, and the other half for the provision of future goods and services. The issue for determination was whether the supply of credit under this system maintained by Mr. Cobalt contravened Section 12CB of the Australian Securities and Investments Commission Act 2001. That provision states that a person must not, in trade or commerce, in connection with the supply or possible supply of financial services to a person, engage in conduct that is, in all the circumstances, unconscionable. The primary judge found that the supply of credit under Mr. Cobalt's system was unconscionable because it went well beyond that which was necessary for the protection of his own legitimate interests, and it operated to tie the Aboriginal customers to dependence on Mr. Cobalt's store for the provision of necessities in life. However, by a 4-3 majority, the High Court disagreed, determining that Mr. Cobalt's conduct was not, in all the circumstances, unconscionable. This decision is significant because it reinforces that the concept of unconscionability requires a very high level of exploitation or victimisation of the vulnerable, and that the bar is no lower than that developed in equity. Indeed, Justice Edelman expressed the opinion that any lowering of the bar of the statutory concept of unconscionability may only be possible if the word unconscionable is replaced with unjust or unfair. McCabe Curwood has significant knowledge and expertise in each of the areas of law that I've touched upon in this video, namely the immunity of legal professional privilege and the concept of unconscionability, both at equity and under statute. Do not hesitate to contact us if we may be of assistance to you with a legal problem.